Intrinsic aids. Those are things within the law itself which can contribute to making the purpose simpler. The judge may find the long title, the short title, and the preamble, if any. Older laws typically have a preamble that lays out the intent of the Parliament to pass the statute. Current laws typically do not have a preamble or have a rather short one. For instance, the 1968 Theft Act specifies that it is an act to modernize theft legislation. The lengthy title may also explain in more detail the intent of the Parliament. The uncommon procedure has been taken in the Arbitration Act 1996, where the declaration of values of the Act is laid out in paragraph 2. This is a major development in the legislative process and one that could both promote and support the implementation of the objective approach. Other important internal supports include any headings before a set of parts and any schedules added to the Act. Often there are also marginal notes outlining the various sections, but this is not regarded as giving the clear intent of the Parliament, because they will have been inserted after the debates in Parliament and are only useful statements made by the printer. Extrinsic aids. These are things that do not come within the framework of the Act. It has always been understood that some alternate sources may further explain the meaning of the Act. Earlier case law. Dictionaries of the time. The historical setting. Previous Acts of Parliament on the identical issues. Society has changed as far as most external help is concerned. Initially, the courts have very strict rules that some extrinsic supports were not to be regarded. But, the conduct of the courts has altered for the following three aids. The three primary extrinsic aids are: Hansard, official report that was said in the Parliament during the consultation on the Act. Reports of law reform agencies, including the Law Commission, which contributed to the implementation of the Act. Foreign agreements, legislation, or guidelines that have been enforced within English law. The use of Hansard. Till 1992, there had been a strict rule that the judges cannot look at what had been said in the discussions in Parliament. A few years ago, Lord Denning had attempted to alter this restriction on Hansard in Davis v. Johnson, 1979, which included the reading of the Domestic Violence and Matrimonial Courts Act of 1976. He confessed that he had read Hansard before making his ruling, saying, "Some might even say that courts must not pay much attention to what has been said in Parliament. They will run around in the dark for the purposes of the Act without putting on the lamp." I do not agree with that view. In the very same case, the House of Lords opposed the idea of this, and Lord Scarman stated their explanations by stating that this content is an untrustworthy manual to the meaning of what has been enacted. This creates ambiguity, not clarification. The discussion and the strain of administrative accountability aren't always favorable to a straightforward and objective interpretation of the significance of the statutory language. Nevertheless, in Pepper v. Hart, 1993, the House of Lords modified the law and agreed that Hansard could be used in a practical manner. The case was unique in that 7 judges considered the appeal rather than the standard 5-member jury. Those 7 judges would include the Lord Chancellor, who was the judge who disagreed through the use of Hansard. The plurality took the view that Hansard could be consulted. In his judgment, Lord Brown Wilkinson said, "The discriminatory rule must be modified in such a way as to allow access to legislative material in which a. the law is vague or unclear or contributes to ridiculousness. b. the information on which it is centered consists of one or even more statements made by a minister or other supporter of the bill, along, if needed, with other parliamentary material needed to understand these statements and their effect. I wouldn't go any further than this at the moment." Thus, Hansard may be viewed only if the sayings of the Act are unclear or vague or result in ridiculousness. Even with that, Hansard should be used when the minister has made a clear announcement passing legislation that would address the confusion or inconsistency. The Lord Chancellor rejected the use of Hansard on realistic terms, pointed out all the time and cost of Hansard's work in each situation. The only occasion that Hansard is required to be used more broadly is when the court considers the legislation that has incorporated an international treaty or a European mandate into English law. This was found out by the Queen's Bench Divisional Court in Three Rivers District Council and others v. Bank of England, 1996. In this kind of case, it is necessary to view the law fairly incompatible with any EU content, and the court may find ministerial declarations, even if the law does not seem to be vague or unclear. Hansard has been stated in a number of instances since 1992, sometimes even as there has been no confusion or irony. The Lord Chancellor's projections on expenses have been verified by some experts, one of whom reports that 25% has been added to the bill. On any other time, it is evident that Hansard was not supportive or that the court would have reached the same conclusion in any case. In Jackson et al. v. Her Majesty's Attorney General, 2005, the Law Lords approved the use of Hansard as an aid to interpretation of the law. They said, in some places, the Pepper v. Hart concept is actually under some kind of legal storm. Part of that is due to the history of the court, whose references to Hansard never support. In addition, that does seem to be related to a continued misconception of the limited role of ministerial comments in this area. It would be tragic if Pepper v. Hart were now to be marginalized. The decision in Pepper v. Hart is true in practice, dismissing as it did a self-created judicial paradox. There are times where ministerial declarations become helpful in action as interpretive assistance, maybe in particular as confirmatory aid.